I see Silvia is still connecting to audio. I hope she manages soon. For those who do not know me, my name is Mariolina Liantonio. I am a professor of European Administrative Law at Maastricht University and also the editor-in-chief of the Review of European Administrative Law. And it is in this framework that for a while we have been organizing what we have called European Administrative Law Dialogues. We are now up the fifth edition of the dialogues, if I am not mistaken. And this initiative was born out of the desire of the editorial board of the Review of European Administrative Law to try to build a strong community of European and comparative administrative lawyers around certain themes that would be of interest for many of us working on European and comparative administrative law. So we have had the first dialogue that concerned the role of comparative administrative law in shaping European administrative law. We had a second event on the role of comparative administrative law for US administrative law. We have had another dialogue on the role of procedural principles in European and comparative administrative law. And we are here today in the fourth, actually not fifth, but fourth edition of the dialogue, where we will focus on the role and potential of administrative remedies in European and comparative administrative law. I want to thank first our speakers for joining us today, and because of the focus of this event today, we have decided to split the presentations and also the discussion in two parts. So I will first give the floor to Professor Widershoven, who is Professor of Administrative Law at Utrecht University, who will give a general overview on the role of administrative remedies in a comparative perspective in Europe. And thereafter, I will give the floor to Professor Robert Thomas, who is Professor of Administrative Law at Manchester University, and he will focus specifically on one type of administrative remedy, which is very prominent in UK administrative law, which is that of the tribunals, and specifically immigration tribunals. The speakers will speak for 12 to 15 minutes, and then there will be some time for a Q&A. After that, we will move, Iseult, who is also member of the editorial board, Professor Marik, a member of the editorial board of the Review of European Administrative Law, and she's also in charge of managing our blog. I will give the floor to Iseult, and thereafter we will have Professor Alberti, who is Professor of EU Law at the University of Ferrara, who will discuss in general on the role of the boards of appeal in European administrative law. And thereafter, Iseult will give the floor to Professor Biondi, who is a professor of EU Law at King's College in London, and also the vice chair of the Board of Appeal of ACER, so the agency of energy regulators. And then after that, there will be a second round of Q&As and a general discussion. So without further ado, thank you again to our four speakers for being with us today. And I leave the floor to Professor Widershoven. So Rob, the floor is yours.
Thank you, Mariolina. Okay, Dana, you can start yes, there it is. The PowerPoint. Okay, my aim is to, dear audience, it's my aim to task even to set the scene of the dialogue of today and provide you with, at least that's the way I have understand it, with a comparative overview of administrative remedies, pre-trial remedies applied in Europe. And indeed, I give this overview with a view to the contribution to contribute to the further development of the system of boards of appeal, and a system which is discussed in the second part of the dialogue. We can go to the second, yes, the second slide. Now, first, okay, no, that's already the third one. So, yes. First, now I have to define where I'm talking about. Now, I'm talking about formal dispute resolution mechanisms as precondition for an action for judicial review to what I've called the real courts, either ordinary or administrative. So it are pre-procedures. These remedies are applied more or less in every country of Europe, and also, as we will see, at the EU level itself. They have some common characteristics. They are normally more accessible, informal, cheaper than judicial remedies. They provide for a more intensive and less differential review of the ex contested, and they function as a filter mechanism and relieving the court of the disputes, and so that's of course also very important. I think in Europe we have two models of pre-trial administrative remedies. First, which is most common at the continent, that is the intra-administrative objection procedure. At least it is applied in the Netherlands. Okay, I'm from the Netherlands, so that's the one thing I know much about. But it's also applied in Germany. It is applied in a certain way also in France, and also in Slovakia. But because we know that from the case of Puškar, which I discuss in a second. Okay, in this inter-administrative objection procedure, the administrative review is done by the same or by a higher administrative authority, and is a precondition for action for judicial review to the administrative courts. So that is more or less the continental approach. But then we have the UK approach. That's the tribunal system. That started, I come to that later on, also as an administrative review, but has developed into a true judicial remedy in two instances, still preceding the real appeal of the appeal to the Court of Appeal, the ordinary courts. So that is the tribunal system, and now we'll give some more insights on both models. Again, we can go to the next slide. I start with the intra-administrative objection procedure and with the general characteristics. It is mostly, in most countries, not always, a mandatory form of administrative review as precondition with judicial review, as I already said. It is applied in the Netherlands, then it's called bezwaar, so you learn some Dutch as well. It is also applied in Germany, Widerspruchverfahren. In France, they have more or less the same, the recours administratif préalable. That is only mandatory by accession, I have understood. But hereafter, I will focus on Netherlands and Germany because I know the most about. Now, these procedures have a dual function. They provide for legal protection for the individual, but they are also, and that is perhaps important, a second chance for the administration, because they can be used to improve the initial decision by extending the statement of reasons, or by adding in the legal base which was forgotten in the first place, etc. And therefore, but we come to that later on, it can also be, it is possible that this procedure leads to a so-called reformatio in peius, the situation in which an individual is placed in a less favorable position than he would have been had he not objected. And that is possible in Germany, also sometimes in the Netherlands. So that is important to note. The obligation, by the way, to exhaust such remedy, the remedy itself, the inter-administrative objection remedy, is not a remedy in the sense of Article 6 of the European Convention or 47 of the Charter. But in fact, it is seen, the obligation to exhaust just remedy, as a limitation to the right of remedy, at least of 47 of the Charter, but a limitation that is legitimate under Article 52.3 of the Charter, because it pursues three legitimate aims, and that is as decided by the court in Puškar, because it offers the opportunity to remedy more quickly a lawful situation, more quickly than before the courts. Then it relieves the court of disputes, a filtering effect again, and in the third place, it increases the efficiency of this procedure, because if the case goes to court, then the court has already a process record which has been created in the objection stage. So that are the three advantages also recognized by the Court of Justice. Now, then a few words about the procedural institutional aspects. Now, the remedy is very, sorry, I'm still there. Still, it's accessible. It is cheap, no fee, and rather informal. Nevertheless, it should meet some requirements, but in fact, that are the requirements of Article 41 of the Charter and of good administration. That means fair, impartial, reasonable time, and right of defense. Okay, but not impartial, but not independence, for instance. Now, the right to be heard is therefore important. There is a right to have legal assistance, not an obligation, by the way. Now, objections, that is the procedure, are lodged to the administrative authority adopting the initial decision, and at least in the Netherlands, decision on the objection is also taken by this authority. So it is really the same authority doing the procedure and also the decision. In Germany, the same authority can decide as well if the authority agrees with the objections. But if the authority does not agree, then the case should be referred to the so-called Widerspruchsverfahren, and that is usually a hierarchical next higher authority. So then a different authority decides about the case. Coming now to the next slide. In the Netherlands, this rule in Germany is of course justified by the idea of impartiality, that the decision maker should be impartial, and therefore is moved to the next higher authority. In the Netherlands, we don't do that, but there are some elements which enhance an impartial process. Namely that parties are often heard by an advisory committee consisting of an external chairman, a lawyer, and other members, and that might be experts, if the area is an expert area, but also other civil servants, not involved in initial decision making. So that is the way to enhance at least a partial, to some extent, impartial decision making. This committee advises the deciding authority, but the authority is not completely bound by the advice, but if you want to deviate from it, it must be motivated in a sufficient way. Then the standard and scope of review. In a procedure for inter-administrative objection, there is a reconsideration takes place of the initial decision by the authority on both legality issues and expediency in full. And that includes errors of law, errors of facts, appraisal of facts, also technical facts, but also policy aspects, because it is an authority, so it can include policy issues as well. And what I already said, review may lead to a reformation pace, at least in Germany. In the Netherlands, it is not, that is so-called not possible, but there are many exceptions, though, so I don't think it's that much different from Germany. Now, the reconsideration by the authority is guided by the grounds raised by the parties, but these grounds do not limit the scope of review per se, because, as already told you, authority is allowed to maintain the initial decision based on new investigations and new legal grounds. So they can also try to save the decision. Now, reconsideration is done ex nunc, on the basis of law and facts as they are at the moment of when the decision on objection is taken, ex nunc. And it may even amount to a real de novo assessment of the initial request, and that is in the Netherlands, or especially done in tax and social security cases. In other cases, the grounds are more leading. Come at the end to the remedies. What are the remedies? The first remedy is, of course, the outcome of the case is rejection of the objections, and that possibly after the authority has replaced the legal base, or improved the legal base, or improved the statement of reasons, and that can lead to the rejection of objection. If the objection is well founded, In the Netherlands, the initial decision is revoked and the authority takes a new decision, substituting the contested one. Okay. In Germany, the initial decision is repealed or modified. Yeah, it is. I don't think it's really very different. And the remedial decision in that case is taken in coordination between the authority that took the initial decision, and that is the uitgangsbehörde, and the authority deciding on objections, that is the Widerspruchsbehörde. And then afterwards, the actual judicial review before the administrative court is against the decision on objections, and defending party in the procedure is the administrative authority that took the initial decision, but that is quite logical. Then coming for a few words, but should take care of my time. Next slide, please.
So about 5 minutes, Rob.
5 minutes, okay. I don't have to go that deep on the UK tribunal system, because that's also discussed by Robert Thomas in the next speaker. But the system started from in the beginning of the 20th century, perhaps even at the end of the 19th century, as a dispute settlement mechanism, being part of the machinery of administration, and for which the government or the sponsoring department was responsible. In areas as social security, I mentioned, then tax and employment, asylum, etc. But it has developed during the years with a lot of commissions. I can say more about it, but will not do that today. After the implementation of the recommendation of the Legat Committee, there was a committee what was advised in 2000. And it is now, it has changed into a two-tier judicial system offering legal protection, which is accessible and formal, but also independent in two instances: the first tier tribunal and the upper tribunal. UK tribunals are tribunals within the meaning of Article 6. That's different from the administrative objection procedure. And therefore, for instance, the guarantees for judicial independence are the same as for judges of ordinary courts. The tribunals sit in panels composed by, first, judges legally qualified, but also members with a substantive expertise in the area concerned, accountants, physicians, and they provide for an oral hearing in public. The process is cheap and accessible. There is only a small or no court fee, no risk to pay for expensive other parties, and no mandatory legal assistance. Of course, there is the possibility to have legal assistance. Coming to my last slide, the standard of review, especially the first tier tribunal, provides for a full review. I always read, not a limited one. And that implies a substantive review of the merits of the case. And I always hope to learn something from English people. What is that about? But a review is indeed more intense than the differential legality control by the UK courts. The scope of assessment is usually limited by the grounds raised by the parties and ex tunc. However, as I have learned from literature, tribunal procedures have a rather inquisitorial nature, and the tribunal may tactfully assist the applicant in developing his case. Now, and the remedies are, generally, it can differ between all these tribunals, to confirm decision and quash the decision whole or part, and then they can either remit the case to the authority to take a new decision, or substitute its own decision for the decision being appealed against. Against these tribunals, there is a statutory appeal before the Court of Appeal, but you need a leave for appeal, and that's my last remark. This leave is only granted, as I have understood, in exceptional circumstances, if the case raises some important points of principle or practice, or if necessary for other compelling reasons. That has been decided by the Supreme Court in the case of Card. So, but there is a possibility of higher appeal after the tribunal. So, ladies and gentlemen, that was what I have to say. Two systems developed in a complete different way. One stayed administrative, the other went from administrative to judicial. So that might be an interesting split, which is also important for the BOAs. Thank you for your attention.
Thank you very much, Rob. And indeed, it's really the purpose of this dialogue today to discuss what administrative systems and how they have developed in Europe can feed into the discussion on the boards of appeal and their development, or vice versa, whether the discussions that took place when the boards of appeal were set up could feed back at the national level. But before we move to that, I leave the word to Robert, who will take us within also the UK tribunal system with specific focus on the immigration one. Robert, the floor is yours. You are still muted, Robert.
Sorry, my fault. Classic Zoom error. Can you see my slides okay?
We can, but if you run them, we probably will see them better. So if you run them at the bottom, just to, you know, run the show, run the PowerPoint show, that might allow us to see them a little bit bigger. But that said, it's really not a problem if you want to show them like that. They're absolutely visible, so don't worry.
All right.
Yeah,
okay.
That's all right.
So thank you very much, and thank you for the opportunity to speak about the UK. So I'm going to give like a general overview of the situation in the UK, and I'll say something about immigration tribunals, but also like social security. So some distinctive features of administrative law remedies in the UK is that there is no like code of administrative law or administrative procedures. The system has like grown and developed over time and incrementally. It's never been like comprehensively reformed, and it depends very much on the context, the administrative context about what the remedies are. So generally speaking, we could say that the structure of administrative law redress in the UK, there are three main remedies: judicial review, tribunals, and also complaints. And complaints include ombudsmen, and ombudsmen are a very important part of administrative law in the UK. In terms of actual decision-making, actual administrative functions, the overall system distinguishes between individual decision-making, and when government is making individual decisions, more often than not, the remedy is a tribunal. And then there's just this whole other range of tasks and that's called public service delivery, and that mostly generates complaints, including complaints to ombudsmen. So there are both internal and external remedies. And the internal remedies are like administrative reviews and internal complaints handled by public bodies. And the external redress mechanisms are tribunals and ombudsmen. So this is like a very simplified overview of the system. So we have government decision-making or governmental actions, and we have tribunals here. And tribunals decide appeals, and I'll talk more about that. We have judicial review, which is traditionally the focus, but it's not everything. And those judicial reviews go to the administrative court. There's actually some difference between where immigration and non-immigration cases go. There's complaints to ombudsman, and then there's the government department reviewing its own decisions through initial administrative like internal administrative review. So it's a very large system. Tribunals, as Rob very correctly said, tribunals in the UK, they are part of the judiciary. So this is like the whole of the judicial structure, with the UK Supreme Court at the top, the Court of Appeal. The administrative court here does judicial review, and there's all different types of courts, but these are the first tier tribunal and the upper tribunal. And these are basically, they are called tribunals, but they are like de facto lower level administrative courts that decide appeals against initial decisions. So if we take, for instance, immigration and asylum, the first tier tribunal, or this chamber, decides like asylum, makes asylum decisions and immigration decisions, but it only hears appeals from decisions taken by the government department responsible, which is the Home Office. Tribunals were reformed in 2007. Previously, they were part of the administration. They sort of occupied this like somewhat ambiguous position. They were neither part of the formal judiciary, but they weren't governmental either. But they were reformed and they were brought into this overall system. There's many different types of tribunals, and they all operate in their own individual silos, their own individual contexts. And there's big differences between how they operate. So, for instance, immigration and asylum, it's very adversarial. Okay. Social security appeals are quite inquisitorial. And there's different procedures and quite different cultures between different parts of the tribunals. And even this account is incomplete because there are tribunals that sit outside of this structure. So what are tribunals? How do they operate? Well, this is a picture of a very typical tribunal hearing room where the parties will meet. And the tribunal judge will hear the case, she will or he will hear the case. Now, tribunals decide appeals, and the vast majority of tribunal cases will be fact specific. So the upper tribunal, it's mostly about hearing the evidence, hearing what somebody's case is, and making judgments, making findings of fact. And then applying the relevant rules. And the vast majority of first tier tribunal decisions are like based on the facts and the evidence. The tribunals will have to apply the relevant rules. They can't just make a decision in someone's favor. They've got to apply the rules and regulations that the government has set down, and they can substitute their decisions. Tribunals do not review initial decisions. They decide appeals against them. And actually, in most cases, the tribunal will start off not by looking at the initial decision. They'll start off by hearing from the person concerned and reconsidering the case de novo. I mean, in many cases, the actual initial government decision, it won't be that important because the tribunal will hear the evidence for itself. It will have to look at the evidence at the date of the initial decision in most cases. There are some exceptions to that, and one exception to it is asylum cases. So social security tribunals, this is the largest system in the UK. It decides 100, 200,000 cases per year, 200,000 appeals. It's very big because the benefit system is the largest administrative system in the UK. So this system, it sort of includes both internal checking of decisions, and this is called administrative review. So before someone goes to the first tier tribunal, they've got to go back to the government department and ask it to review its decision. Then they can go to the tribunal. Administrative review is seen as preferable by government because it's quick, it's cheaper, it's efficient, but it's not independent. There's no hearings, and if anyone is well advised, they would end up going to a first tier tribunal, and then if they disagree with that decision, they can go to the upper tribunal. The upper tribunal is made up of senior tribunal judges. They specialize in particular areas. The legal rules that tribunals operate are very specialist. They are detailed, complex. They're continually changing. So, like the immigration rules are over 1,000 pages long. Social security law is very complex and detailed. So these are very specialist areas of law. The same goes with tax and so on and so on. So tribunals are like specialist decision-making bodies. The whole system, it works reasonably well. It's not perfect. The tribunals are independent. They make reasonably good decisions. The caseloads can be high, and tribunals are, they've got a lot of cases to decide, and some of these cases are very factually complex and legally complex, and there's just there's a lot of throughput of cases and decisions. So that's pretty much how tribunals operate. It's very much up to government which particular decisions can be appealed to tribunals, because tribunals, they have a statutory jurisdiction, and it's really government that has a lot of influence over whether there are or not rights of appeal to tribunals, and if so, what particular types of decisions can be appealed to tribunals. So going back to immigration, the government about a decade ago reduced the number of initial administrative decisions that could be appealed. So the other main remedy I want to highlight is ombudsmen, which are a really big deal in the UK. There are 5 ombudsmen. They don't decide appeals. They look at governmental actions and public services. They look at maladministration and promoting the principles of good administration. And ombudsmen have advantages. They're free of access. Well, tribunals are, but ombudsmen are investigative and inquisitorial. You don't have to go to a hearing, and they do decide some quite important matters. Ombudsmen do. So I'm going to give you 2 examples of 2 big recent ombudsman reports that have come out. This was a report that was published a couple of months ago. It's about whether the Department for Work and Pensions properly communicated the increase in the women's state pension age. And the Ombudsman has found maladministration by the Department for Work and Pensions, and it's recommended a financial remedy that could cost between £3.5 and £10.5 billion. This affects 3.8 million women in the UK. This is a really big report, and we're waiting for the government's response on that. We won't know, because at the moment there's a general election campaign in the UK, so we have to see who wins or loses the general election. But that's a really big report. Another big report is by the Northern Ireland Public Services Ombudsman about the handling of benefit claims, and it found systemic maladministration by the relevant department in Northern Ireland, and it made a whole load of recommendations to improve the process. This is one example really of a big administrative system, the benefit system, where the tribunals were deciding individual cases and on a one-by-one basis, and then the ombudsman comes along and says, look, there are problems with the way decisions are being made, and the ombudsman made all of these recommendations, which most, not all of them, have been implemented. It's very difficult to summarize this report because it's about 300 pages long, and the ombudsman's report is similarly quite long. So what I'd sort of say if I go back up here, what I'd sort of say in summary is tribunals are judicial. They are staffed by tribunal judges and also specialist members, and they soak up a lot of the administrative law litigation that goes on. If someone doesn't have a right of appeal to a tribunal, what can they do? They can go for judicial review, or they can go they can complain to an ombudsman, or they can ask the government decision maker to review its decision. There are pros and cons with each of these methods. Going for judicial review is costly, it's legalistic, it's adversarial. It's not the type of thing that somebody, would necessarily want to do by themselves without a lawyer. Ombudsmen have their advantages, but their decisions are not legally binding, but they are independent. So like that's the overall system. I'm more than happy to elaborate on any of that and any questions, but I think I'll leave it there, and thank you for listening.
Thank you very much, both Rob and Robert, for introducing us to the system of administrative remedies, objection procedures, and the tribunal system. I would like to open the floor now for questions, remarks for our 2 speakers before we move to then the second part of the seminar. I don't see immediate raised hands. So maybe I see Isoult who has a thumbs up. So, but in the meantime, perhaps I could kick off with one question that I have for Robert to start with, and that is that well, in my course, comparative administrative law, we always well, when I try to teach UK administrative law, I always say that well, the tribunal system is very diverse. That's a little bit also what you were saying. So I just wanted to prompt you. Of course, the focus of your intervention today is on the immigration tribunal. To which extent also there are kind of generalizable conclusions on the tribunal system. For example, I knew that there was an environmental tribunal and it was discontinued. I'm not sure, or anyway, it was definitely not as busy as the Social Security or Migration Tribunal that you are you just talked about. So yeah, I was just wondering to which extent it's possible to draw any general overarching conclusions. But before you answer, maybe I give the word first to Andrea and then to Isoult. But Andrea has now frozen because we knew there were electricity problems at his place. So Isoult, oh no, Andrea, you're there?
I'm back. Can you hear me now? Okay,
yes,
good.
Yes, we can. Please.
Yeah, sorry, just a quick question to Robert, because you mentioned that obviously even tribunals can be costly. Do you have any sense about the general idea about how much does it cost, whether there's a sort of, you know, different kind of problems for different kind of tribunals, or whether, I mean, just go through the tribunal route?
Thank you, Andrea. And Isoult.
Yeah, I also have a question about the specialization that you just mentioned, Robert. I don't know if you can say a little bit more. I mean, you said that the specialization of tribunals comes because the legislation or the regulations are so complicated. But do you think that it has also an impact on the kind of outcome of the cases? In the sense, if there was the same thing as tribunals, but as a special court within the judiciary, would that change the outcome or not? That's difficult to say because it's a counterfactual thing, but there may be some elements to consider in that reasoning. Thank you.
Robert, do you want to go for a first round?
Yeah, thank you very much. So in terms of the cost, I think it depends on whether it's like the cost to like the parties, the litigants, or the cost to the government. So that would vary between different tribunals. I mean, you've got a bit of a distinction between the high volume mass decision-making tribunals, and on the other hand, you've got a tribunal like, for instance, I didn't mention the Competition Appeal Tribunal, which is called a tribunal, but it's like de facto a specialist branch of the High Court with lawyers, and there are big companies, and that's a world away from, say, a Social Security tribunal. So I don't think there's been research on that. It'd be quite interesting to do, really, because I suspect the government itself hasn't considered that, and that's a very interesting point. In response to Isoult, I think what I'd say is, well, tribunals are called tribunals, but basically, in substance, that they're courts. When the general public, when they think about a court, they think about a criminal court, and when you're dealing with, say, Social Security claimants, and many of them are in vulnerable circumstances, they're told, well, they could go to a court, they might think, oh my God, I don't want to go to a court. I don't want to be accused of a crime. So that sort of label of tribunals has stuck. But in terms of specialization, it's not just in specialization in the law. It's like the tribunals being aware of the sorts of cases, the sorts of issues that come up. So, for instance, in asylum cases, a very common issue is, well, is this person telling the truth? Are they credible? How do you assess credibility? In Social Security cases, it's like, well, what type of health conditions do people have? How does it affect their mobility, their functional capacity, and those types of things? So in practical terms, there's there's a difference. There's a difference of name, but in substance, courts and tribunals are pretty much the same, and they both make like legally binding decisions. So yeah, thank you for that.
Thank you. I think Dacian had a question, and then Rob.
Yes, thank you. Hello, everybody. Dacian Dragoș from Romania. A question for both speakers. Would you say that the tendency now in administrative law is to favor or to go more towards empowering alternative methods or alternative dispute resolution methods, or it's going back to the empowerment of courts in a larger sense? Because we are seeing this in many countries, this fight between specialized, resolution of disputes by the tribunals or internal review or external review, but still specialized, and by courts. And at least in my country, but in other countries as well, in Austria, for instance, they have undergone a lot of reforms that first they were trying to actually get rid of internal review, or administrative review, because it's, not so independent as the courts. But in the end, they end up with the same mechanism, but a little bit different. The same is in Central and Eastern Europe, in other countries, and of course, in France, there are discussions about the role of administrative appeals and mandatory versus optional and so on, and only the tradition, prevents this to become the main venue for challenging administrative acts. So how do you see in Netherlands and in the UK the tendency towards empowering tribunals, or going back to the courts and making sure that they are, of course, impartial and independent when new tasks are assigned? Mm-hmm. When you need a new remedy, for instance, a new judicial review in a new field. Thank you.
Sorry, Rob, sorry, I was muted. If you, can you maybe answer Dacian's question, and then you have a question yourself to Robert, I guess, and then Robert gets the chance to have a final round of replies before we move on.
Yes, then first the answer to Dacian. There are always many developments at the same time, but I think at the moment there is a development of deformalizing all these procedures, both the objection procedure, but also the procedure before the court. Objection procedures are now they are experimenting with all kinds of ways to come to a solution. And we call it the development to more responsive dispute settlement. And in this regard, systems are used as take the telephone, ask these people what their problem is, and then try to solve it, and don't steer at formal hearings. So there is really a deformalization trend going, and it's not finished yet. Also, that is at the objection procedure area, but. Before the courts, we have mediation experiments in the Netherlands, but I think in other courts as well. They are used, especially also in civil servant cases, but also social security. But there are mediation possibilities. They are less successful, I believe, than everybody hoped. But in cases of finances, for instance, compensation cases, these things are done a lot. Because then we can get rid of all these formal rules and just try to come to a middle ground. So indeed, there is a tendency in this regard. Then my question to Robert is, in fact, the assessment, the review, but I cannot use the term the appeal on the merits. I have always promised to understand what is meant by it, and that is, I think, an important issue which is now also pending before these BOAs. The BOAs, on one hand, they should not apply the differential approach of the courts. They should be more intensive, but nobody knows what it is. At least, and I think we can learn a lot about the English tribunals, especially, by the way, perhaps not the Social Security. I can understand that they just take a new decision, but especially also this competition tribunal and perhaps also the migration. At the end, who decides where, in cases of uncertainty or technical issues, to appreciate the facts in the light of the legal requirements? Is that the tribunal or the agency or the authority? These kind of things. How far does it go? The test on merits.
Thank you, Rob. That's a wonderful question to make the bridge then to the second part. So, Robert, the floor is yours for a final comment before we move to the second part. And then for those who still want to ask questions, there will be time in the second part of the Q&A. Robert.
It's really interesting to hear about what's been said about ADR and mediation. There's been this discussion in the UK. So tribunals are not alternative dispute resolution. If you take, for instance, like Social Security decisions have never been challengeable to the courts. There's always been tribunals for over a century. The concern about ADR with for instance, mediation in like the administrative law context is that there's a risk of people mediating their rights away, of settling for less than they're entitled to. So attempts at mediation, as in Rob mentioned in the Netherlands, they're not been as successful in the UK as people, you know, as they thought they could be. So there's skepticism towards ADR when it comes to the individual and state relationship. There's an inequality there, and if people are pushed down this road of mediation, they might end up with fewer entitlements than they're actually, should receive. So the tribunals are judicial. They can hear cases. This is why, for instance, Social Security tribunals are inquisitorial, because people don't have representation. And, you know, you're talking about quite a considerable inequality between the individual and the state. So I think what you have to think about is what is the best and most appropriate remedy in the particular types of cases that you're receiving, and looking at the context, the relationship between the parties. What do they want out of it? And what's the best way, most efficient and fairest way of resolving those particular disputes that arise? And I don't think there's like one size fits all. So it depends, depending on the context. So to come to like Rob's question, appeal on the merits, what does it actually mean? It means the tribunal redeciding the case and making its own decision for itself. Now, you know, in the UK, we draw this big distinction between judicial review and appeal. And judicial review, it's got a variable standard of review, but the court doesn't decide for itself whether the government's policy is a good policy or a bad policy. The role of tribunals is much more focused. It's about individual decisions. Someone's claimed social security benefits, they've been turned down. They can, in that type of situation, they would have very little benefit from going to judicial review, because all the judicial review court would say, well, has the decision maker applied the correct rules, had a fair procedure, and made a reasonable decision? If it hasn't, then the decision would go back to the decision-making body to be redecided. But what someone really wants in that type of situation is just a good decision. So it's quicker and cheaper and more efficient to have a tribunal that can redecide it. And as I've said, like social security cases have always gone to tribunals and never to judicial review. So that's the big difference. So deciding appeals on the merits, it means that the tribunal makes its own decision on the facts and the law about someone's circumstances. But most tribunals, like immigration, social security, and so on, they're concerned with the individual's decision. They're not like reviewing policies. And there are some tribunals actually which do have a judicial review jurisdiction. So, for instance, most immigration judicial reviews are now decided by the upper tribunal. There's other types of tribunals that will decide, have a limited judicial review jurisdiction, but the legislation must say that. So the norm is that tribunals redecide on the merits on issues of fact and law. So I hope that helps. Thank you.
Thank you very much, Rob. There are always things to learn each time you explain something about tribunals. I pick up something new, so that's really excellent. Thank you so much for explaining and being so pedagogic about tribunals. So I suggest we move to the second panel, and I know that there have been questions in the chat, but I suggest we take them for the second round, if it's all right by everyone. So, Jacopo, I think you will explain to us the broad landscape of Board of Appeals at EU level, and then we will move to Andrea, which we will have a more specific example. Thank you very much to both of you.
No, thank you. It's a pleasure. Yeah, exactly. We decided altogether to focus just on one specific type of administrative review at level. Of course, there are many different types of administrative review at the level of the European Union, as well as the Ombudsman, for instance, or very interesting stuff within each specific agency. The European Medicine Agency has got one specific administrative review mechanism, which is very interesting. But of course, the most interesting animals on the landscape are the Board of Appeals, by far. It's on the block, I could say, even if they're not so new, actually, because the first Board of Appeal that actually came out at EU level is, as everyone knows, the one of the agency that we now call EUIPO, so Intellectual Property Office.
Jacopo, sorry to interrupt you, but we hear you very poorly, or I do hear you very poorly. So maybe you can speak a little bit more in the mic if it's possible. Sorry for that interruption.
No worries, and thank you for giving me this feedback. Now, does it work better, or perhaps I can try without the microphone?
Like this is okay, Jacopo, but you need to then, I guess, hold the mic close to your mouth.
To eat the mic, basically,
yes.
Which is not very tasty. So Board of Appeal came out with the EUIPO office, what we now call EUIPO at that time, of the harmonization of the internal market, so trademarks and design. So basically, this has been the very first Board of Appeal established at EU level. Now we got 8 different Board of Appeal at EU level. Of course, it depends on what we deem is a Board of Appeal. If we say that Board of Appeal actually take mandatory decision, as actually Rob was arguing before, then the Board of Appeal at EU level are 8 different bodies, in the sense that we got a Board of Appeal for intellectual properties, the very first one in '93, if I remember correctly. Then we got the one for the Community Plant Variety Office, and then we moved to aviation safety, the registration of chemical substances, and so on and so forth. And so we got this 8 number of Board of Appeal. We basically take decisions that are mandatory for the agency. The agency has to respect and apply the decision of the Board of Appeal. However, there are other bodies as well. For instance, the one established within the SSM, the Single Supervisory Mechanism, therefore within the European Central Bank. In that case, the Board of Appeal, which is called Administrative Board of Review, actually take a decision which is not binding for the ECB, and therefore it becomes something quite different in comparison with the other bodies. And the brand new anti-money laundering authority, who has already been basically created by the legislator, but the founding regulation has to be published yet in the official journal of the European Union. But the brand new anti-money laundering agency will have a Board of Appeal as well. but this Board of Appeal will be a fake Board of Appeal in the sense that it will take decision that will not be binding for the brand new authority. So Board of Appeal at EU level basically come from a very functionalist perspective, like almost everything at EU level, isn't it? So basically there has been no project behind the creation of Board of Appeal. And I'm wondering, I would like to ask to Robert and Rob whether this is also the case at national levels. Perhaps that's also the case at national level. But at EU level, there was no project behind it. And basically Board of Appeal started to be created because the European agencies and the European Union and the Court of Justice of the European Union need them, reduce the workload of the same Court of Justice, to have some specialized guys to overview very technical acts adopted by the agencies. This is the great idea behind. And actually, when Rob before was saying that actually administrative level remedies at national level have been created also to be more accessible, cheaper than courts, actually that does not really apply for boards of appeal of European Union agencies. They are not cheaper than courts, or at least perhaps the lawyers will ask you a lower fee if they have to represent you before a Board of Appeal than before the General Court of Justice. I don't know exactly about that, but before the Court of Justice and the General Court, you do not have to pay any fee for lodging an appeal. Whereas before the Board of Appeal of the EU agencies, you do have to pay a specific fee. So they're not cheaper, in fact, than EU courts. And they are not more accessible than EU courts, I would say. Andrea Biondi will take the floor after me and is very aware of a specific decision taken by the Acer Board of Appeal, where the Acer Board of Appeal tried to get rid of Plowman to some extent. You know, Plowman, the very ancient ghost that is running in Luxembourg since the 60s. But actually, even Board of Appeal have to apply Plowman. And therefore, and sorry, I was very technical. Plowman is this very ancient decision by the Court of Justice of the European Union reducing the access to justice for individuals before EU courts. And therefore, boards of appeal as such are not more accessible than courts. Basically, their idea, their rationale is to reduce the workload of the Court of Justice and the General Court and to step in for very technical cases. They are quite different one from the other. And again, that's something which is coherent with the national experience with Board of Appeal, if I got correctly from Robert and from Rob. However, their heterogeneity, so the differences between the different Board of Appeal established within EU agencies are actually quite important in terms of how they are made, so how they are composed, how you can remove members. So there are Board of Appeal which gives greater guarantees than others. So for instance, if a member of the Board of Appeal of the EU IPO, so Intellectual Property Office, has to be removed, the Court of Justice has to give an authorization, so as to protect the independence of the Board of Appeal of the EU IPO. For the Single Resolution Board, so for the appeal panel of the Single Resolution Board, or for the Joint Board of Appeal of the European Supervisory Authorities deciding upon banking financial matters, just the management board of the same agency, in accordance with the European Commission, can remove a member because of serious grounds. So you understand that here the regulated entity basically has got the possibility to some extent to remove a member of the controller, which is something that actually does not sound very rule of law-ish, I would say, so very, very independent-ish. And these made sense in the past when Board of Appeal has to remain administrative places for review. So they had to remain places where basically the technical decision of agencies had to be reviewed as a very first instance, and then there was the General Court of the European Union, and then again, the Court of Justice of the European Union. But nowadays, actually, things are changing quite importantly for two very reasons. So first of all, as perhaps you already know, and I'm sorry about it for being obvious, since 2019, the statute of the Court of Justice has been amended, and therefore there are 4 different boards of appeal whose decision basically cannot be brought to the attention of the Court of Justice, or the Court of Justice can decide upon the decision taken by these bodies just, I mean, in case of extremely serious and important grounds are meted. And therefore, basically, this filter mechanism has now been expanded because the reform of the Statute of the Court of Justice has already been decided, but has to be published in the official journal of the European Union. Yet, I think that in the coming weeks it will be published in the official journal. So the reform of the Statute of the Court of Justice that will see the light of the day in few weeks basically expand this filter mechanism to all the decision taken by all the boards of appeal. So basically now the decision of all the 8 boards of appeal established within the European Union agencies will basically not be controlled by the Court of Justice, but just by the General Court. And this basically tells you that now these guys are really part of the judicial machinery. I'm not saying that they are judges, in no way, of course, but they do belong to the general system of protection for companies and citizens. Moreover, 2 years ago, that's another topic that Andrea Biondi knows very well, the General Court and then the Court of Justice has taken a decision in the Aquind case. And in the Aquind case, the General Court, first of all, and then the Court of Justice have said to the Board of Appeal, well, you know what, you have to perform a deeper scrutiny over the decision of the agencies, a full review of the decision of the agencies. As Rob was saying before, what does it mean is absolutely obscure. So what full review means is quite difficult to be understood. But you have to do so, dear Board of Appeal, because we, the General Court, have to limit ourselves to, let's say, an overview over the legitimacy of the act from a formal perspective, because we do not have the technical and scientific expertise for going deeper. From these two things, so first of all, the filter on appeal, and second, the fact that the Board of Appeal have to perform a deeper review, because if they don't perform a deeper review, the General Court cannot respect Article 47 of the Charter. I think that from these derives the fact that we should reconsider the role of the Board of Appeal of European Union agencies and ask ourselves whether it makes sense that they do remain full administrative bodies, as more or less are right now, or whether they should evolve towards a more judicial nature. And actually, the legal and political scholarship is quite divided among these two parts. Personally, I'm more on the second one, because I think that nowadays we should face the reality and realize that perhaps we should make this body more judicial, so as to counterbalance the recent trends that we are facing since 5 years or so. However, I also think that the functionalist approach is always good. It's always needed. And the last point that I would like to make before leaving the floor also to the discussion, and to Andrea, first of all, of course, is to bring to your attention the fact that I think we should not be trapped between this distinction between administrative nature and judicial nature, which is very intriguing from a speculative perspective, from a theoric perspective, but from a practical perspective, I think it misses the point. Because first of all, the point is to make Board of Appeal more efficient, full stop. Many of them are already very efficient. I'm thinking about the UIPO, Board of Appeal, so the one of trademark and designs. Others are not, and are efficient just because of the people that are working within it, that are extremely excellent professional, that on a part-time basis step in as member of the Board of Appeal. However, they do exist at this time, Board of Appeal, where the registrar is a part of the agency. So basically, the registrar is a civil servant of this legal service of the agency, which is the controlled entity, which is on the one hand is an employee of the legal service of the agency, and on the other hand is the registrar of the Board of Appeal, namely the entity that should control the agency. In terms of financial resources, so Board of Appeal have no specific line of the budget of the agency to finance their job. The only exception are Acer and the SRB. All the other Board of Appeal are not sure of the budget that they can spend over the years. There is no immunity for the member of the Board of Appeal. No worries, even less than 5 minutes. There is no immunity and privilege for the member of the Board of Appeal, as so there is basically no privilege and immunity, and that's a strong contrast with regard to the judges of the Court of Justice and the General Court. So I think that we should be much more focused in understanding what we need for Board of Appeal. Of course, from a theoretic perspective, we can discuss, and I would be happy to do that afterwards, between their administrative or judicial nature, but a much more pragmatic approach, I think it would be more useful, at least in the short term. Thank you for your attention.
Thank you very much, Gianjacopo, for bringing some of the points that have been made by Rob, Article 47, for instance, and then by Robert regarding also the importance of the context. I think that something that you just mentioned very clearly. So I will give the floor to Andrea for discussing the ACER Board of Appeal. Please.
There we go. Can you hear me fine?
We do.
Excellent. Well, thank you so much, and I'm truly enjoying it. And thank you, Jacopo, because obviously when there you go, they start drilling. Sorry, I do apologize in advance, but there's some drilling in the background. I hope it's not going to disturb you too much. Now, I was saying that it's interesting because obviously, you know, while you're doing it, you simply get on with the job. So this is a little bit of an opportunity for me again to think about certain kind of issues that sometimes you know, you don't have the time even to get on when you're doing it. And Jacopo is a hero of ours, actually, because he's got a wonderful website and a page with a lot of decisions and material on Board of Appeal. So, you know, we are extremely grateful. Anyway, let's get on with what I wanted to say. Now, first of all, I had to, you know, the usual sort of customary disclaimer that what I'm going to try to say in the next 10 minutes or so is obviously just my personal views, and you know, what I'm saying does not engage at all, you know, the Board of Appeal. I always wanted to say this. I never had the opportunity, so you know, let me say it, and that's why the personal in red. No, but you know, it's not just to show off or whatever, but you know, because some of the decisions are still live, some of the decisions are actually being appealed before the General Court. So obviously, I will refrain from commenting some of just to deal with the substance, but I will try to simply limit myself to some, if I may, some very down to earth reflections, considering my experience as Vice Chair of the Board of Appeal in the last couple of years. So what I will do very quickly, just really to give you an idea what we're talking about, what is ACER, what's the board, then a few considerations about how we function, you know, in terms of composition, in terms of workload, and how we approach the cases that are in front of us. And then perhaps, you know, just to offer you some possible reflections and considerations for the future. Now, in terms of what we do, as I say, the Board of Appeal of ACER reviews, obviously, ACER decision, that is to say, the decision taken by the EU Agency for the Cooperation of Energy Regulators. Now, just to keep it very simple, of course, this is an agency that is quickly and rapidly changing its broad competences in reflection of the many changes that are actually occurring also in the energy market. But again, as to say, just to keep it simple, I think that, again, probably we cannot go as far as to define ACER as the EU energy regulator, because in theory, the main task of ACER is simply to help, to assist national regulatory authorities. In other words, they need to simply supplement national authorities. In reality, what you know, the kind of powers that ACER have is mostly either soft law instruments, that is to say, ACER can actually issue recommendations, reports, inquiries, again, in order to help national authorities. But at the same time, they can also adopt binding individual decisions. I'll come back to that point in a second. Those decisions are usually taken after sort of, when the NRSA or the TSO fail to find an agreement. So in other words, ACER steps in and simply regulates a specific measures. Obviously, once the ACER adopts a decision, that means that they do regulate the area, the specific area. They have power to have direct approval in certain kind of cases. They have the power to propose amendments and so on and so forth. ACER, can step in and issues individual decisions in certain specific regulatory areas, which are mostly the cross-border issues. For instance, security of supplies, capacity mechanism of energy, when you have to determine some kind of common methodology which can be applicable to all the energy market and so on and so forth. The Board of Appeal, us, we are part of ACER, so we are part of the administrative structure of ACER, which is composed by the administrative board. The administrative board is mostly the budget of the agency. The board of regulators, which comprises representatives of all the national regulatory authorities, and the director of the agency, which has a coordination role, but also at the same time is the authority that actually signs off the ACER decisions. As I said, we are part of the administration, but at the same time, we are independent, and we are supposed to act independently, obviously, from all the other parts of the agency. Now, the Board of Appeal has very specific jurisdiction and very specific kind of ACER decisions, which are listed in Article 2 of the ACER regulations. We don't have the time to go through all of them. Now, that said, let me just try to explain a little bit, how, Jacob would say, how this animal operates. The Board of Appeal of ACER is composed by 6 members and 6 alternates. Now, the 6 alternates means that in case there's a conflict of interest, there's any other impediments of one of the 6 members, we can actually replace 1 or 2 more members. So far, we more or less decided most of the cases that just the 6 of us. Now, in terms, I think that perhaps Jacopo mentioned this a little bit. I think that could be interesting just to focus on a couple of points. Now, first of all, in terms of composition of the board. Now, I checked, and the previous 2 Board of Appeals of ACER were mostly composed by former energy regulators. In other words, experts in engineers, experts in economists, and so on and so forth. And they also did not get any money for it. The new board, the one I'm currently sitting on, that took the start, its mandate in October 2021, is instead split between 3 lawyers, and that's just our chair, who's a former judge of the General Court, and 2 academics, and 3 energy experts, once again, energy regulators, former energy regulators. A big difference is that we are getting paid, and if you are interested, it's a commission decision, so you can check online exactly how much we get. My view is not that much, but it's never enough, obviously. But that's an important point. That's an important point because obviously you do actually not do this as a mission. But again, I think it's fair that we get somehow compensated. And within all the members, both the members and attendant members, usually we elect a chair and 2 vice chair. Independence is the usual stuff. It's always there's an obligation to publish every year or any kind of possible conflict of interest or any other problems, and now everything is online. I think that probably quite intriguingly, it's nice to look at a little bit on numbers. Workload. The very first Board of Appeal, just 2 appeals, then the second Board of Appeal, 19 appeals. Now, so far, we dealt with 13 appeals. So you can see a steady increasing number of appeals. Now, obviously, within these 13 appeals, I'm counting also joint cases or also relaunching proceedings and so on and so forth. which obviously, they might have some specific similar issues, but at the same time, you still have to issue a decision. So I think that it's fair to say that we have 13 appeals, which again, shows you a little bit like the increasing importance of energy sector regulation and possibly litigation. Now, as Jacopo mentioned, to get now to what we are actually doing, we have a list of serious and quite cumbersome, if you might say so. And as Jacopo mentioned, our duty is to ensure a full review of any specific case. The General Court first and the Court of Justice in the Aquin case gave us a very specific benchmark and very specific reference framework for our action, which is once again to ensure a full effective protection of individual rights. And then that means that we need to exercise a full extensive reviews of every kind of specific issues, technical, complex ones, and so on. So the idea is that protection of rights and full and extensive review. That is to say, is not enough just a mere a limited review of a manifest error or assessment. That's obviously the famous bit of Aquin, which is fair enough. But I'd just like to remind you that there's a second side. There's two sides of the Aquin litigation: full effective review, and at the same time, the court made it very clear that the whole idea of Board of Appeal review system is to ensure also a quick, accessible, and inexpensive mechanism for protecting the rights. Full review, but quick. And I think that's and sometimes perhaps those two things might also be a little bit in contrast. So perhaps let me just then try to make some observation how we dealt with it. And I'm sorry to be so practical, but I think just to give you an idea. For instance, we have to ensure that the decision is taken within 4 months deadlines. And again, we're talking about rather complex issues. And here I just show you a little bit how we did it in one of the very first cases that we dealt with. And we had oral hearing in February, and we managed to publish the final decision on the 29th of April. So, I thought we did quite well. Obviously, I did actually use an example where we look good. There have been more complicated decision, which took a little bit longer. But I'd just like to mention one specific point here that obviously after the hearing, we had a general discussion. But what we decided to do internally was to simply assign the case to not just one rapporteur, but 2 rapporteurs. So in other words, the case, our case goes to a legal rapporteur that focus on, in the first instance, on the legal issues presented by the specific case, and at the same time to a technical rapporteur, which is the one that trying to understand, to try to explain and work a little bit more on the, let's say, on the complex and technical issues that these cases can actually arise. Probably that's something that's been done by all boards. I don't know, I'm not sure about that, but we decided to make it a little bit explicit, and even in the decision, we do actually report who is the legal rapporteur and who is actually the technical rapporteur. That is to say, there are 2 people really working very, very closely on a decision, and then once the 2 rapporteurs agree on a sort of draft, then it gets submitted to the whole board for general discussion and so on, and then finally the final decision. So that's a little bit how it works. Now, I'm sorry, I'm going a little bit over time, but some reflections. Again, extremely practical point, if you don't mind. As mentioned before, we are from one side, we are there to, we need to ensure a full review of the case, fine, and at the same time, we need to act quickly and efficiently. So how do we do it? Well, there are, elements from both sides. I noticed that all parties, they're very happy to, the parties, they actually have the right to have their case heard in the language of the case. But then in all cases that we dealt so far, parties were happy to subject everything to use just one language, which is English, which again makes lives a little bit easier because you don't have to go through the translation. You have all the auto in English. We all work in English, so it actually helps in terms of in terms of being a little bit faster. At the same time, probably on the other side, in order to ensure full and extensive review, what we did so far, we made quite a lot of extensive use of specific powers which are available under the rule of proceedings of the board. That is to say, for instance, because sometimes you are actually facing quite complex issues, the board is actually entitled to ask for further documents or for further reports or any other possible documents which can actually enlighten certain kind of obscure points. And we also made quite a lot of use of Article 17, which obviously contains a classic national procedure and a classic procedural law principle. That is to say, you cannot actually have new pleas keep on adding new pleas, but then there are specific exceptions to that rule when there's some new developments or some kind of other elements that actually should be taken into account. Just to give you an example, we often ask parties if they have any further comments on perhaps, let's say, a very relevant judgment of the European Court of Justice that occurred between the submission of the pleadings and perhaps the oral hearing. And I think that, again, we really had some really good relationship with parties that are usually quite keen to provide those informations. Again, in terms of providing a full extensive reviews, I can see that 99% of the cases parties do tend to require a public oral hearing, which is conducted in a straightforward adversarial form in terms of questions from the bench, the rejoinder, and so on and so forth, with purely adversarial. We also made use of the possibilities of and accepted quite a lot of, in certain cases, the fact that parties might actually also rely on expert witnesses and other technical supports. Again, in terms of the decision themselves, I think that it's positive to make explicit that the outcome, our decision, are the sort of the labor of exactly this sort of mixture of legal and technical expertise. And again, if I may, we also try, in order to ensure, again, a quick and accessible form of scrutiny, we also work a little bit on how the decisions of the board are presented. And I don't know if Jacopo agrees or not, we're trying not to be a little bit more concise and a little bit more straightforward and try to cut these less relevant issues than before, avoiding long citations from regulations and so on and so forth. Because in our view, in my view at least, maybe that's my common law side, conciseness sometimes does help. Obviously, raise the question, resources, but I won't deal with that. Really, if I have 3 minutes,
very shortly, please.
Shortly. Obviously, there are so many issues. So I gave you a very nice picture. We do everything right, fantastic. But there are so many issues. Once again, for instance, what we're dealing here with reviews of individual decisions of ACER. What does it mean, an individual decisions? Because in reality, these decisions are all addressed to all national regulatory authorities, all TCOs. So are they in reality not individual decisions, but of general application? In a recent decision, we believe that actually these are actual decisions of general application that should be called regulatory act. And obviously, that's true, as Jacopo mentioned, there might be some issues in terms of legal standing. And probably also another further complication is that because obviously once you actually, the board of appeal decides a specific case, can be appealed before the General Court. The General Court obviously is entitled to review only the legality of the Board of Appeal decision, not the merit of the decision of the administration. So therefore, if the General Court does annul the decision of the Board of Appeal, what we have to do is obviously to restart another proceedings in order to comply with Article 266 of the treaty, because we obviously need to ensure that we comply with the judgment of the General Court, which means once again that for the parties, if we simply either confirm or reject or if we confirm the legality of the Commission or the ACER decision, again, parties need to start the proceedings again, and also vice versa. So obviously there is a little bit of further complication in terms of efficiency speeding, because obviously we are also required to ensure compliance with the judgments of the General Court. Anyway, that's just a little bit of a general overview of what we are trying to do. Anyway, hope it was interesting.
Yes, thank you so much. That was super interesting, very detailed, and thank you for also the details on the procedures and how you packed everything together. I think it's really fascinating. So I will open the floor to everybody amongst you as to take questions or to try to answer some of the comments that Jacopo made during his presentation. Because I think for me, from putting together the first and the second panel, there seems to be a big difference about the context, because Robert was emphasizing the importance of protecting individuals and the asymmetry of power between the individuals doing the review and the state, let's say, or the department as a whole. And when you are talking about the Board of Appeals, my understanding is more that all the people asking reviews are more, let's say, big economic entities, if I'm correct, or maybe I'm wrong, but then it would be nice to have that kind of factual information, or to try to see if we are actually really talking about the same kind of asymmetry of power in your cases in the second panel or not. Or maybe it depends, because there's 8 of them. Jacopo.
Of course, I think that Andrea will give a much better explanation on these, at least from the perspective of Acer. From a general perspective concerning all the boards of appeal, I think that we got a good balance. There are boards of appeal, because of course the applicants are the recipient of decision-making by the agency. Sorry, I was forgetting to eat the microphone. So of course it depends on who is the addressee of the decision taken by the agency. There are agencies that take decisions against or vis-a-vis big economic groups, and perhaps Acer is one of them. I don't know, I will leave the floor to Andrea on this. And as well as ECHA, the European Chemicals Agency. I think it targets quite huge companies. Other agencies, such like the UIPO, basically the trademark office. Everyone, I mean, also a citizen can ask for registering a trademark at the UIPO, and therefore can become the applicant before the Board of Appeal. So I think it's a quite good mix. It highly depends on which agency are you considering.
Well, in terms of Board of Appeal of Acer, I would say that generally, because the Acer decisions are mostly addressed to the national regulatory authorities and TCOs, obviously you do have, these are the parties that are appealing our decision. And again, because the question I'm dragging to the question of standing, we did recently have joint cases which were instead brought by large energy companies, which obviously felt that one race decision did actually affect their interest. And again, this is one of probably the most lively question here in terms of who can actually have access to the Board of Appeal proceedings. And as Jacopo mentioned, our rules says that you still need to prove direct and individual concern, which obviously it's a very restrictive reading. But if you are particularly interested, you can have a look at the Uniper and the Board of Appeal decision, where we try somehow to highlight that there might be a little bit of a problem, as if we consider that Acer decision can be considered as regulatory acts, then obviously under the treaty you need only to show that you're directly concerned and not individually concerned. But again, it's an open question. The case has been appealed before the General Court, and obviously will be up for the General Court to decide whether the requirements of individual and directly individual concern, which is provided for by the Acer regulation, our rules of proceedings, is the right one or not. But so that's enough. But will be for the General Court.
Thank you. I don't know if there are other questions. There is a question in the chat by Islam, but do you want to say it, or is Islam? I don't know if you want to ask your question.
Yeah, perhaps, but I think it's a question which is posed to me. But
Okay.
let's see. yeah, what is the object of appeal? Yeah, in a system which has an objection procedure, is it the initial decision or the decision on objections, especially when the decision has not changed? Yeah, you can read it, I think. Yeah, I'm not. Yeah, in the Netherlands, but in Germany it can be different. But in the Netherlands, the appeal is directed against the decision on objections. If the decision on objection is the same in the content-wise as the initial one, yeah, then it doesn't matter that much, at least substantively, unless things have changed in between the initial decision and the decision on objections. It is possible that facts have changed and or the rules even, and then it might be important. In Netherlands, at least the decision on objections is the object, and the assessment is extunct from the moment that the decision on objection is taken. So new facts after the initial decision have to take on board. And it might also be possible that that in the procedural objections some procedural rules have been violated, and that then is also tested. So to summarize, it is the decision on objections and the procedure for this decision which is the object of appeal.
Thank
And
you.
perhaps also answer the question of Jacobo, but he has perhaps more about the incremental way the judicial protection has developed. Yeah, if you look at the continent, but if you look at the Netherlands, if you see from the start of the 20th century till now, we had to have everything. We had specialized administrative courts. We had appeal to a higher authority or appeal to the same authority, which is called objections. And we have had everything, but it has been reorganized a bit the same as perhaps in the and not the same, but similar to what had happened in 2007 in the UK. It has been reorganized in 1994, and since then the main procedure of pre-trial procedure is the objection procedure. Objections to a higher authority are very scarce. And also a lot of specialized judicial tribunal-like organizations have been abolished, and so we have now one common first instance. And okay, we have a lot of we have too many high appeal courts, but the system has been reorganized in 1940. It was incremental, but then we made some choices.
Yeah, and you know, that's a very good point that you are making about, you know, how things develop through reforms, because Jacobo was saying something about the distinction between administrative and judicial nature of the Board of Appeal. And I think if I'm correct, you said that we needed to look at it practically, but you mentioned a couple of points where there is no independence, no financial independence, no personal independence, or very little personal independence. And I was thinking, well, should we not have something at the Board of Appeal at EU level, or the general judicial or quasi-judicial architecture, a little bit like the Legat review that Robert was mentioning, in the sense that should we not have some kind of inquiries trying to put the landscape and say, well, what is it that we are doing? Or maybe that's what you are doing with your project. And then maybe you say one word about it. Sorry.
Yeah, I'm not for the one-size-fits-all approach, like Robert was saying before. So I think we have to respect a lot the heterogeneity of boards of appeal, because actually boards of appeal have won against the specialized tribunals, because as we remember, there was the possibility to establish specialized tribunals attached to the general court. Just one has been established on civil service matters, so things that are not so delicate from a sovereignty perspective. And the reason why boards of appeal have won against specialized tribunals, we got 8 boards of appeal and we have no specialized tribunals anymore. It's also because of their heterogeneity and the possibility that they leave to the the legislator of the European Union, to the member states, to design the body that they need, and that is needed to the professional community to which the board belongs. And I think this has to be respected a lot. On the other hand, I think that now the time has come, but I would like to hear the perspective of Andrea and Rob from that on this point. Time now has come to restructure, to see the full picture, to see the full picture and say, okay, I can respect the specificity of each policy field, but maybe now time is sufficiently ripe to create some common standards or to share best practices. And from my perspective, one best practice is to extend the protocol on privilege and immunities that already cover all the functionaries, all the civil servants of the agencies, also to the members of the Board of Appeal. I mean, it's a pity that they do not enjoy that. The second point is to give them resources from a human resources perspective. So the registrar, basically. Financial resources, to protect their financial resources. Acer is already quite well protected, SRB as well, but the others not that much. I mean, it depends from the agency, but the agency is the controlled entity, so you know. And then, of course, you got the removal. So the removal, why we cannot use the best practice of the UIPO and the CPVO, so basically the Court of Justice can remove a member of the Board of Appeal. Why cannot we apply this standard to all the boards of appeal? I mean, it does not. I mean, it seems to me quite fair as a point. Of course, no problem has happened so far. Okay, so no problem at all has happened so far in 30 years of experience of boards of appeal. But I think that it highly depends on the professionality and the capability of the member that the Board of Appeal have been able to bring on board over the last years. But of course, we cannot always depend on the people. Institutions have to be, standalone, and they have to create procedures and standards to protect themselves. And I think that now time is quite ripe to do that, in my view. But of course, many different ways are envisageable.
Okay, I will ask the panel to answer, and then if there's no other question, I suggest we close it here. But yes, please do reply to what Jacopo has asked, if you have any thoughts. Andrea, maybe.
I'll go first. Yeah, well, totally agree with Jacopo. I think that, again, there's a lot of, because again, without sounding, but obviously you do learn a little bit on the job. Clearly there have been problems and issues that perhaps even 5 or 10 years ago maybe did not present themselves. So obviously we're still learning a little bit. And again, the idea of having a little bit of extra interchange or exchanges with other boards, I think is very, very useful. I'll give you an example. We've been thinking about whether it was appropriate perhaps to simply sort of stay proceedings because there was a pending case. And obviously we just noticed there was nothing in our rules of proceedings, and perhaps we can actually have a look at the other Board of Appeals practice and decision practice. I think that was very useful to see what the other boards were actually doing, because again, they've already been through this kind of problem. So that I think of extra communication, dialogue between the different bodies, I think would be very, very helpful. Second point, I think that, again, I didn't want to get on because Daniel started moaning, but resources is an issue, because obviously you do things, which is great, because, we all will, we work as a close unit because we do everything by ourselves with a little bit of help from the registry, but obviously, it does take its toll. So obviously in terms of, if you really want to be serious and make sure that, again, we do comply with our duties, I think that in terms of investment, in terms of resources, I think that's something that I would be very much in favor, because you do actually need a little bit of extra help. Yeah. So I'm thinking about my successors. That would be great. So I completely agree on everything Jacopo said.
Thank you. I think Rob, you were first, and then we will go to Robert. Yeah.
I don't have to add that much. And now, in fact, I always love incremental developments, but then again, at a certain moment, you can try to stabilize the situation. And I think, to some extent, and I think we are now more or less, approaching that situation. And perhaps important is this 50A statute thing. What means that that in fact the BOAs, the Board of Appeal, come in place of the Court of Justice itself, in a certain way. at least the Court of Justice is diminished and the Board of Appeal are uplifted. So that means that Board of Appeal are going from, in technical terms, 41 to 47. At least that is what I think. And that means that some things have to be regulated, and then the requirements of the ideas Jacobo had about everything you said. I agreed about removal, salary, and etc. But indeed, if you make an institution from administrative to a kind of a judge, that will cost some money. And there's always problem, but at the end there will be some money for all these BOAs, I'm sure. And whether we need a legal committee too, I'm not sure. I think it will develop in these directions, although even if we don't have one. But that is what I think, what I expect.
Okay, thank you, Rob. Robert, I know you want to say something, and I will give you the floor. But I have an extra little question for you, because you were saying when you were mentioning the different tribunals, right? That even though it's very complicated and that they are under the same umbrella, they keep their own specificities, and I think it's kind of interesting when we discuss the Board of Appeal and what Jacobo was saying, that, you know, we need one size does not fit all. So if you could just say maybe one thing about this diversity across the tribunals that might be helpful for the general discussion, it would be nice.
Well, I mean, I think that's a very important point, that there's very little merit in imposing uniformity for its own sake, as an end in itself. You know, there's going to be differences between what these bodies do, call them tribunals or courts or boards of appeal. There's going to be diversity and differences, and so there is no one size fits all. I mean, I think like very often as academic lawyers, sometimes we like to think of high level theory about the judiciary and what the courts do, but the reality is that a lot of these bodies, they're pragmatic institutions. They're learning as they go along, and they're very much tend to be driven by practical forces like caseloads and resources, and what tasks they've been given, and also changes in the wider environment, the wider policy environment. So this is an ongoing journey. I don't think there's any single fixed approach or fixed destination point. So it's quite a difficult task, really, because they're trying to balance up different goals. They've got to apply the law and treat people well and reach good quality decisions, but there's pressures on resources and efficiency and caseload, and this certainly in the UK, that's led to some tribunals being repeatedly reformed and overhauled. So this is very much an ongoing project, and I think the very good thing is exactly what has been said by Jacobo and Andrea, is about learning as you go along, and looking at what other bodies are doing, and recognizing that it might have some lessons, but there are going to be certain features that are very specific to each institution. So I think I'd highlight those points.
Thank you very much for this discussion, and I think good to have more questions to all of you, but I think we will need to wrap it up here. So thank you very much for your time. Thank you for the audience. The recording and the PowerPoints of this meeting will be put on the blog in a couple of weeks or so. Time there will be also another meeting of this dialogue in fall with Professor Kitty regarding the general evolution of EU administrative law in general. So if you are all very welcome to attend and to discuss with us. And this is the last dialogue for this academic year. So we will wish you all a very nice summer break, and hopefully we keep the discussion going in different forms, also with the work that Jacopo is doing and its special issue coming up in not too long on the topic. So thank you very much to all of you, and see you soon.
Thank you.
Thank you. Goodbye.
Bye.
Bye.